Question number 551. Under the Commercial Codes Act 2015, time period for filing the written statement is 90 days and is not extendable for any reason whatsoever. B. The time limit of 120 days for filing the written statement is extendable as per Kailash versus Nanko. C. The time limit of 120 days for filing the written statement is not extendable. And D. There is no time limitation for filing the written statement. Here correct answer is option C. The time limit of 120 days for filing the written statement is not extendable is the correct answer. Question number 552. What duration formally under CPC has been assigned to submit the written statement after the date of service of summons? Correct answer here is option A, that is 30 days. And maximum 90 days can be provided with the permission of the court. Question number 553. In a commercial suit, the time limit of 120 days for filing of written statement can be extended if the defendant shows adequate reasons for non-filing, can be extended at the discretion of the court, can be extended under any circumstances. Option D, direct personal appearance of the defendant. Here correct answer is option C, cannot be extended under any circumstances. In a commercial court, the time limit of 120 days for filing written statement cannot be extended under any circumstances. Question number 554. Every allegation of a fact in the plaint, if not denied specifically except as against a person under disability, shall be taken to the untraversed, admitted, proved, none of the above. Here correct answer is option B, that is admitted. Question number 555. The provision of specific denial is provided in option A, in Rule 2 and 4 of Order 8, option B, in Rule 1 and 6 of Order 8, and option C, in Rule 3 and 5 of Order 8, and option D, in Rule 7 and 9 of Order 8. The provision of specific denial is provided in option C, that is in Rule 3 and 5 of Order 8. Question number 556. Provisions relating to set off and counter claims under CPC are contained in. Correct answer is option C, that is Order 8. Question number 557. Which of the following provision is related to set off under the CPC? Options are Order 8 Rule 5, option B Order 8 Rule 6, option C Order 7 Rule 5, and option D Order 7 Rule 6. Here correct answer is option B, that is under Order 8 Rule 6. Question number 558. Set off can be claimed in any suit, in a recovery of money suit, in a suit for possession, in both A and B. Here correct answer is option B, in a recovery of money suit. Question number 559. As per Order 8 Rule 6, particulars of set off be given in none of these: written statement, plaint, both written statement and plaint. Here correct answer is option B, that is written statement. Under Order 8 Rule 6, particulars of set off is given in written statement. Question number 560. Mark the incorrect proposition. First, set off is a statutory defense to a plaintiff's action, whereas a counterclaim is a cross action. Second, set off and counterclaim arises out of the same transaction. Third, set off should not be barred on the date of the suit, while counterclaim should not be barred on the date of filing of written statement. Fourth, claim for set off cannot be exceed plaintiff's claim, whereas the counterclaim can exceed the plaintiff's claim. Fifth, both set off and counterclaim cannot exceed the pecuniary jurisdiction of the code. Here correct answer is option B, that is second only. In this question it has been asked which is the incorrect proposition. The second proposition is incorrect and other propositions are correct, and I am repeating them. Correct propositions are: set off is a statutory defense of the plaintiff's action, whereas counterclaim is a cross action. Second is incorrect. Third, set off should not be barred on the date of suit, while the counterclaim should not be barred on the date of filing of written statement. Claim for set off cannot exceed plaintiff's claim, whereas counterclaim can exceed the plaintiff's claim. Both set off and counterclaim cannot exceed the pecuniary jurisdiction of the court. Question number 561. In a written statement, a defendant can claim option A set off, option B counterclaim, option C both A and B, and option D either A or B. Here correct answer is option C, that is both A and B, that is set off and counterclaim. In a written statement, a defendant can claim set off and counterclaim. Question number 562. A sues B on a bill of exchange of rupees 500. B holds a judgment against A for rupees 1000. The two claims, being both definite pecuniary demands, may be set off. The illustration is given in. Here correct answer is option B, that is Order 8 Rule 6 of CPC. Question number 563. Set off can be legal set off, equitable set off, both A and B, none of the above. Correct answer here is option C, that is legal set off and equitable set off. Question number 564. Under Order 8 Rule 6 CPC, set off may be permitted if the suit is for the recovery of property, set off claimed by the defendant is ascertained sum of money, value of property recoverable is less than rupees 2 lakhs, and D, defendant presents a written statement of the suit. Here correct answer is option B. Set off claimed by the defendant is ascertained sum of money. Set off may be under Order 8 Rule 6 of CPC, set off may be permitted if set off claimed by the defendant is ascertained sum of money. Question number 565. Which of the following is not true with regard to set off claimed by the defendant? Options A. The sum of money must be recoverable by any defendant if more than one. This statement is not true, therefore it will be the correct answer. Whereas other correct options are: the suit must be for the recovery of money, the sum of money must be ascertained, the sum of money must not exceed the limits of pecuniary jurisdiction of the court. Here not true statement is asked. Option A is the not true statement. Question number 566. In which of the following cases C can set off the claim? A sues C on a bill of exchange. C alleges that A has wrongfully neglected to ensure C's good and is liable to pay in compensation. B. A sues B and C for rupees 1000, the debt due to C by A alone. C. A sues B and C is for rupees 1000, the debt is due to C by B alone. D. A sues C on a bill of exchange of rupees 500. C holds a judgment against A for the recovery of debt of rupees 1000. Here C can set off the claim in option D, that is A sues B, A sues C on a bill of exchange of rupees 500. C holds a judgment against A for recovery of debt rupees 1000. Here D is the right answer. Question number 567. A sues B on a bill of exchange of rupees 1000. B holds a judgment against A for rupees 2000. Here options are: pecuniary demand may be set off because both claims are definite. Claims cannot be set off because issues are different. Both A and B are correct, none of the above. Here option A is the right answer. Pecuniary demand may be set off because both claims are definite. Question number 568. A and B sue C for recovery of rupees 1000. C has debt due to him by A alone. Here C can set off the debt against B, set off the debt against A, set off the debt against A and B both. Cannot set off a debt due to him by A alone. Here correct answer is option D. Cannot set off a debt due to him by A alone. Question number 569. A and B sue C for rupees 1000. C cannot set off debt due to him from A alone. C cannot set off debt due to him from A alone as a matter of right. C cannot set off debt due to him from A alone with prior permission of the court. None of the above. Here correct answer is option A. C can set off a debt due to him from A alone. Question number 570. Consider the following statements. A defendant may set up by way of counterclaim against the claim to the plaintiffs any right or claim in respect of the cause of action accruing to him. The counterclaim may be submitted by the defendant even after he has delivered his defense. The counterclaim shall not exceed the pecuniary jurisdiction of the court. Which of the statement is above the are correct? In question number 570, all the statements are correct. Therefore, option D is the right answer. Once again, I am repeating all the three statements. A defendant may set up by way of counterclaim against the claim of the plaintiff any right or claim in respect of the cause of action accruing to him. The counterclaim may be submitted by the defendant even after he has delivered his defense. The counterclaim shall not exceed the pecuniary jurisdiction of the court. All the statements are correct. Question number 571. Provisions relating to counterclaim is prescribed under dash of the Code of Civil Procedure 1908. Here correct answer is option D, that is under Order 8 Rule 6A. Provisions relating to counterclaim is prescribed under Order 8 Rule 6A. Question number 572. If in any case in which the defendant sets up counterclaim, the suit of the plaintiff is stayed, discontinued or dismissed, the counterclaim shall be stayed, nevertheless be proceeded with, may be continued with the leave of the High Court, no specific provision. Here correct answer is option B, that is nevertheless be proceeded with. Question number 573. Which of the following deals with the subsequent pleading of the Code of Civil Procedure? Here correct answer is option A, that is under Order 8 Rule 9 deals with the subsequent pleadings in the CPC. Question number 574. In a suit for recovery of rupees 25 lakh, the defendant files its written statement, pleads that it does not owe any money to the plaintiff, but in fact, he is entitled to recover the sum of rupees 40 lakhs from the plaintiff. The defendant, however, does not file a counterclaim. Can the defendant file the counterclaim at a subsequent stage in the suit or files a fresh suit seeking recovery of rupees 40 lakh? Here, correct answer is option C. That is, the defendant can file both, either a counterclaim or a suit. Question number 575. Which provision specifically enables the court to pronounce judgment in case the defendant fails to file written statement or subsequent pleadings? Here, correct answer is option B, under Order 8, Rule 10 of CPC. Question number 576. When any party from whom a written statement is required fails to produce the same within a fixed time before the court, option A, none of these, option B, the court may pronounce judgment, option C, the court may make any order regarding the suit, and option D, both, the court may pronounce judgment and the court may make an order regarding the suit. In question number 576, correct answer is option D, that is, both, the court may pronounce judgment and the court may make any order regarding the suit. Question number 577. On failure to file the written statement under Order 8, Rule 10 of CPC, the court may pronounce the judgment at once, may order for striking of the defense, may pass any other order, either A, B or C. Here, correct answer is option D, that is, either A, B or C. Question number 578. If the defendant fails to file a written statement, the court would hear the suit ex parte, the court may pass judgment against him, the court shall issue notice, none of the above. Here, correct answer is option B, that is, the court may pass judgment against him. Question number 579. On default, in filing of written statement under Order 8, pronouncement of judgment is mandatory, discretionary, directory rule 10 of CPC, none of the above. Here, correct answer is option B, that is, discretionary. Question number 580. When the plaintiff appears and the defendant fails to file written statement despite service, the court, option A, shall pronounce judgment under Order 8, Rule 10 of CPC. Option B, may either require the plaintiff to prove its case by leading evidence or pronounce judgment against the defendant depending upon the nature of the case. C, shall necessarily require the plaintiff to prove its case by leading evidence. D, direct personal appearance of the defendant. Here, in question number 580, correct answer is option B, that is, may either require the plaintiff to prove its case by leading evidence or pronounce judgment against the defendant depending upon the nature of the case. Question number 581. What a court can do when neither party appears when it is called for hearing. Here, court can dismiss the suit. Option D here is the right answer, that is, dismissal of suit. Question number 582. Dismissal of the suit under Rule 3 of Order 9 of CPC. Option A, bar a fresh suit in respect of same cause of action. B, does not bar a fresh suit in respect of the same cause of action. May bring a fresh suit with the leave of the High Court. May bring a fresh suit with the leave of the District Judge. Here, correct answer is option B, that is, does not bar the fresh suit in respect of the same cause of action. Question number 583. Where a suit is dismissed under Rule 2 or Rule 3 of Order 9 of CPC, plaintiff is debarred from filing fresh suit. Only remedy with the plaintiff is to seek setting aside of such order. The only remedy is to bring fresh suit. And option D, plaintiff may, subject to the law of limitation, bring a fresh suit, or he may apply for an order to set the dismissal aside. In question number 583, correct answer is option D. Plaintiff may, subject to the law of limitation, bring a fresh suit, or he may apply for an order to set the dismissal aside. Question number 584. Where neither party appears when the suit is called on for hearing, the court may make an order that the plaint be returned, the decree be passed in favor of the plaintiff, the suit is dismissed, the plaint be rejected. Here, correct answer is option C, that is, the suit be dismissed. Question number 585. A suit can be dismissed in default under Order 9 Rule 2, Order 9 Rule 3, Order 9 Rule 8 of CPC, or D, both B and C. Here, correct answer is option D, that is, both B and C, that is, under Order 9, Rule 3 and Rule 8 of CPC. Question number 586. In which of the following rule, if a suit is dismissed, the plaintiff shall not be precluded from bringing a fresh suit in respect of the same cause of action? Here, options are Rule 3 of Order 9, Rule 9 of Order 9, Rule 21 of Order 11, Rule 9 of Order 22. Correct answer here is option A, Rule 3 of Order 9. Question number 587. A fresh suit in respect of the same cause of action is permissible when the suit is dismissed under Order 9 Rule 8, when a suit is dismissed under Order 9 Rule 3, where the suit abates under Order 22 Rule 3 Clause 2, where the plaintiff abandons the suits under Order 23 Rule 1 Clause 1. Here correct answer is option B. A fresh suit in respect of the same cause of action is permissible when the suit is dismissed under Order 9 Rule 3 of CPC. Question number 588. Which of the following order a court may pass under Order 9 Rule 3 of CPC in a suit where neither plaintiff nor defendant appears on fixed day of hearing? Options are simple adjournment, option B dismissal of suit, option C imposition on cost, and option D adjournment sine die. Here correct answer is option B, that is dismissal of suit. Question number 589. Choose the true statement about propositions. Propositions are: where on a fixed day it is found that summons has not been served on the defendant in consequence of the failure of the plaintiff to pay the court fee, the court may dismiss the suit. Second, where neither party appears where the suit is called on for hearing, the court may make an order that the suit be dismissed. Third, where a suit is dismissed under any of the above case, the plaintiff will be barred from a fresh suit. Assertions are: in question number 589, correct answer is option A, that is first and second are correct and third is incorrect. Question number 590. Where the plaintiff appears and the defendant does not appear when the suit is called for hearing, and it is not proved that the summons was duly served, the court shall issue a warrant of arrest of defendant. Option B, hear the suit ex parte. Option C, dismiss the suit, and option D, direct a second summons to be issued and served on the defendant. In question number 590, correct option is option D, that is direct a second summons to be issued and served on the defendant. Question number 591. A suit may be dismissed where, after a summons has been issued to the defendant and returned unserved, plaintiffs fail to apply for fresh summons under the period of. Here correct answer is option C, that is 7 days. Question number 592. Where the summons to the defendant is returned unserved and a plaintiff fails to apply for issuance of fresh summons to the defendant within 7 days of the return, the suit of the plaintiff is liable to rejected under Order 7 Rule 11 of CPC, dismissed under Order 9 Rule 10 of the CPC, dismissed under Order 9 Rule 5 of CPC, either A, B or C. In question number 592, correct answer is option C, that is dismissed under Order 9 Rule 5 of CPC. Question number 593. An application under Order 9 Rule 7 of CPC can be made within 60 days of the order, within 30 days of the order, at any time on or before the next date of hearing, at any time during the pendency of suit. Correct answer here is option C, that is at any time or on before the next date of hearing. Question number 594. Where the defendant appears and the plaintiff does not appear when the suit is called for hearing and where a part of the claim is admitted, the court shall dismiss the whole suit, dismiss the suit so far as it relates to the remainder, pass the decree of the whole claim, proceeds ex parte proceeding against defendant. Here correct answer is option B, that is dismiss the suit insofar as it relates to the remainder. Question number 595. Where a suit is wholly or partly dismissed under Order 9 Rule 8 of CPC, the plaintiff may bring a fresh suit, shall be precluded from bringing a fresh suit, may bring a fresh suit with the permission of the court, none of these. Correct answer here is option B, that is shall be precluded from bringing a fresh suit. Question number 596. A suit dismissed under Order 9 Rule 8 of CPC for non-appearance of the plaintiff can be restored under. Correct answer here is option A, that is under Order 9 Rule 9 of CPC. Question number 597. After dismissal of suit under Order 9 Rule 8 of CPC, a fresh suit on the same cause of action under Order 9 of Rule 9 CPC is barred, is not barred under any circumstances, is not barred subject to the law of limitation, none of the above. Here correct answer is option A, that is barred. Question number 598. When the defendant is proceeded ex parte after filing written statement, the defendant cannot participate in future proceedings. The defendant can participate in future proceedings. The defendant to participate in future proceedings must ask for setting aside the ex parte order. The plaintiff has the option to allow the defendant to participate. In question number 598, correct answer is option B, that is the defendant can participate in future proceedings. Question number 599. In the Code of Civil Procedure, an ex parte decree can be set aside under Order 9 Rule 5, Order 9 Rule 10, Order 9 Rule 13 and Order 9 Rule 11. Correct answer here is option C, that is under Order 9 Rule 13. In CPC, an ex parte degree can be set aside under Order 9 Rule 13 of CPC. Here option C is the correct answer. Question number 600. An ex parte degree can be set aside on the ground of summons not duly served, being prevented by any sufficient cause from appearance. Only A is correct, both A and B is correct. Here correct answer is option D, that is both A and B is correct. An ex parte degree can be set aside on the ground summons not duly served, being prevented from any sufficient cause from appearance. Here option A and B is the right